Good night. This is U.S. Immigration Attorney Sharifa Tharp. I am here live to take your U.S. immigration related questions. Now, tonight I have a great topic for you, and I am also here to answer your immigration related questions. So you can start putting your questions in the comments. It doesn't matter that your questions are not related to the topic that I'm talking about. It can be anything that's immigration related, but I'm going to be talking about the waiver, how you can apply for a waiver. This is asking for forgiveness for an overstay if you don't qualify to stay in the U.S. and apply for your green card. So I always talk about who qualifies to stay or the categories of immigrants who qualify to stay in the United States and apply for their green card, even if they're out of status. But tonight I'm going to talk about the opposite. So I'm going to start from this point. We've already determined in a consultation that you don't qualify for adjustment of status. That's why it's very important to schedule a consultation, because that is where you're going to get a full evaluation about what are your options regarding staying in the United States and applying versus what are your other options if you can't qualify. But the only way to know whether you will qualify in particular is to determine whether which one will work for you based on your particular circumstances. Now, so we're at the point in a consultation where we have determined you don't qualify for adjustment of status. The next thing is, are there any alternatives? So a lot of the times I look to the waiver to see if this could be a way for you to be able to qualify for permanent residence, even though you're in the United States and you're without status. So let me go to the questions for a minute. Hi there, Natasha. Nice to see you. If an SB1 request got denied, what would suggest the person do next? So it's Pinksbury. It's going to depend on what the circumstances are. I wouldn't be able to give specific advice about what they do next, but what I would say is schedule a consultation, because that's where they're going to be able to explore other options. So for example, if they get denied the SB1, then they may very well have to apply for the immigrant visa and then permanent residence all over again. Do they qualify for that? And so that would be the next question in my mind. But to confirm that and to determine whether that step is the right step for you, a consultation would be required. Now, to schedule a consultation, go to the link in my bio. It'll take you to the website where there are different ways to get in touch with the firm. Right now it's after hours, so there are after hours receptionists who answer the call, take your information, and then pass it on to a scheduling coordinator for the next business day. They can get you on my schedule to speak about what those next options could be after doing a more detailed evaluation. So I overstayed 2 weeks from I was 16, and I never get back a visa. So Rudy, when you overstay, they definitely don't look kindly on that, and that can affect your ability to get another visa, unfortunately. All right. So Pinksbury, you are welcome. So now, how do you qualify for this waiver? The waiver is called a provisional unlawful presence waiver, or the I-601A waiver, or the extreme hardship waiver. And the extreme hardship waiver already hints to you what may be required. And what's required here is that you have a U.S. citizen or legal permanent resident, spouse, or parent who will experience extreme hardship in the case that you don't get the green card. And so remember that if you don't qualify for adjustment of status, then the next thing is, do you qualify for anything else? Tonight I'm talking about that alternative, the waiver, but not everyone who qualifies for permanent residence qualifies for this waiver. You have to have this qualifying relative who's going to be the U.S. citizen or legal permanent resident, spouse or parent. So let's see. All right. So, if your qualifying relative will face these circumstances and these conditions of facing extreme hardship if you don't get the green card, then that's where I get to work for my clients, because this is not the type of fill in the blanks type of application. Actually, no immigration application is. So if you do have that assumption, you may be in for a harsh surprise. In this case, the waiver does take legal know-how, it does take skill, coordination, strategy to effectively communicate to the immigration officer why your qualifying relative, remember your U.S. citizen or legal permanent resident spouse or parent, will face these conditions. So let me go ahead and see if there's anybody else who has a question before I move on. So Pingsbury, you're welcome. All right. So, what are the benefits of this waiver? So first, this waiver presents options to those who are stuck in the United States. They can't leave, but they can apply for the green card in the United States. The reason you can't leave, the reason the waiver is so important is because if you've overstayed over 180 days, and then you leave the country, you will be barred from returning to the United States for 3 years. If you overstay over a year, that turns into a 10-year bar. No green card, no visa, no re-entry into the United States for that period of time. And even after that, you could face an uphill battle to get a visa. And so when you're applying, when you're in a situation where you do qualify for permanent residence, but you can't leave to attend your interview at the embassy, the waiver, an approved waiver here, will be your solution to help you to be able to leave the country and not face the consequences of that bar at your interview. So Rudy Tech said, if you don't feel like you've gotten enough information, that means that you need a personal consultation, because I don't give specific legal advice here on the live. I don't provide personal legal advice, and so you must schedule a consultation if you want to get more detailed information. Now, Rudy Tech said, what if you overstayed for 2 weeks? They don't look very kindly on overstaying. Even if it's overstaying over 2 weeks, you don't want to be in that situation. If you know that you need to extend your stay, what you should do is schedule, you should file for an extension. However, keep in mind, I don't know what your situation is. I don't know your history. And so that's where the consultation is very important. Because remember, I'm not your attorney and I'm not giving personal legal advice. I'm giving you information that's helpful, but not information that you should be taking any action on until you get a personal consultation. I want to marry a foreign national with a tourist visa. May I petition for a green card for my new spouse? So Roberto, so I want to marry a foreign national who has a tourist visa. May I petition for a green card for my new spouse? So it depends, Roberto, on what is your status here in the United States. Are you a U.S. citizen? And is your spouse here? Has circumstances changed that would allow them to stay? That has caused them to stay here? If that's the situation, generally speaking, spouses of U.S. citizens who are here, even if they're out of status, even if they've overstayed, may qualify to apply for adjustment of status. But whether you are eligible in your particular situation to do this, or whether this is right for you, is going to require a consultation. I can't stress this enough. You want to get a consultation before you do anything to make sure that you don't make any missteps, that you do go by the book and do everything correctly to avoid mistakes. So, but I was a kid, I was 15 years old. So unfortunately, even though you were 15 years old, now if you were 15 years old, right? There is no such thing as unlawful presence for a 15-year-old, because children, anybody who's under 18, they don't accrue unlawful presence. That means to overstay over 180 days to get the bar, but that doesn't mean that they don't look harshly on an overstay of the visa by even a few weeks. That is still a violation of the terms of the visa. And so unfortunately, it still goes against you, and the officer can use their discretion to do that. All right, so great questions so far. Now, for those of you who you want specific information to actually take action and move forward in your particular immigration matter, schedule a consultation. There are different ways that you can schedule the consultation. You can go to the link in my bio. It's going to take you to the website where it's pretty easy to navigate, and it's pretty easy to know exactly how you want to get in touch with us, if it's by contact form or by phone, and on weekdays, even online chat. So go ahead and do that. I urge you. I cannot say enough how important it is to get a personal consultation. Now, I have been talking about the I-601 provisional unlawful presence waiver. The benefit of the waiver is that it prevents you from facing the harsh consequences, the 3-year bar or the 10-year bar, once you leave the United States to attend your interview at the embassy. And now, to qualify for this waiver, you also have to make sure that you have no other disqualifying issues in your background. So, for example, no criminal issue that renders you inadmissible, or no other immigration violation that renders you inadmissible, like misrepresentation or fraud. However, at the point that we're applying for the waiver, I do vet my clients to make sure that this process is going to work. And now, at the point that it has been approved, then you are at an advantage, because at that point you have an approved waiver that would be able to allow you to attend your interview at the embassy. And once you go to the embassy with this approved waiver, the officer will not hold the unlawful presence against you. And within a few weeks after you get your immigrant visa, you'd be able to return and be unified with your family again. So this waiver is really for individuals who they don't qualify to stay in the United States. And the purpose of the consultation is to first make sure that you don't qualify to stay in the United States, because I do also work with my clients to find solutions. The first preference for me and my clients, of course, is to stay in the United States and apply for permanent residence. However, if you don't qualify for that, there's the alternative. And the alternative is the waiver in this case. So schedule a consultation, and then let's first evaluate all your circumstances, determine which solution would work best for you, and then get started on your process. Now, what does this process look like? So once we determine you qualify for this, the first is that your relative or employer, if you qualify through an employer, is going to file the petition. Once it's approved, then you're going to go on to apply for the waiver. So you attach the waiver to the waiver to the approved petition, and then wait for a decision. All being well, an approval comes on the petition, on the waiver. That means that you are well on your way to be able to get the permanent residence at the embassy. Once your interview is scheduled, then you could leave within a matter of weeks or days before your interview to prepare for your interview, attend your interview, and then all being well, within a few weeks, be able to return to the United States. So a consultation costs how much? Where does this take place? So Roberto, I do 3 types of consultations: in person, if you're here in Florida and you're right around the corner from me, I do video and phone because I represent my clients in all 50 states and around the world. And so I offer them very convenient ways to meet with me. And when you become my client, I also continue this of meeting my clients in different ways, just depending on where they are. The cost of the consultation is $150 for up to an hour. It is worth your time and money. It is a detailed consultation where I go through your facts and to determine whether you qualify. I let you know your options, whether other options exist, how to approach your situation, and I can also be your attorney should we determine you qualify and you want me to be your attorney. Is there a waiver for misdemeanor that results in CAT? So I'm not sure, Jay, for real. Usually when you're given CAT relief, that's a Convention Against Torture relief. Usually there's no waiver for that. It's just, do you qualify for CAT? So schedule a consult and we can get into the nitty-gritty of what your situation is and what the best solution could be. If I overstay at 15 years old for 2 weeks, can I apply for a waiver? So with this, really the denial of your visitor's visa, I don't know your situation, Rudy texted, but based on the general information, the visitor's visa, the officer has great discretion to deny your visitor's visa. And it is basically based on the fact that you haven't proven to their satisfaction that you can maintain strong ties to your home country. And so that's why they deny it. In this case, overstaying for 2 weeks it doesn't render you inadmissible, so there's no waiver for that. But what happened is that because this is still a violation of the terms of the visa, they don't look kindly on that, and they use their discretion to deny you or to be able to determine whether you are at a great risk for overstaying in the future because of this past violation. So there are different, it could be different reasons why you have been denied and repeatedly denied your visitor's visa. Just because it is very discretionary, that means that it's really up to the officer's judgment to decide whether they want to give you the visa based on you pass based on anything that's in your background. It's really up to the officer to decide how they want to do it. And yes, you're in a tough situation because you're not inadmissible and they're just using their judgment. So it's a tough situation, and it is frustrating. Okay, so Miss Chan, I'm sorry that happened to you, and I'm so happy that you could still join us under the circumstances. So it's nice to see you. And thanks so much for the love. I appreciate it. So that's all the information I have for you tonight. I talked about the waiver. Now keep in mind, I talked about the waiver as an alternative, but I evaluate all the circumstances involved to determine whether adjustment of status, that's to stay in the U.S. And apply, would be best, or whether there are alternatives. And so the best thing to do is get your matter evaluated thoroughly in a consultation. And you can do that by going to the link in my bio. Hi there, dearest. It's nice to see you. Thanks for joining in. Now, I am going to head out for the night, but as usual, I am going to be back around 9:30 p.m. Eastern. And you come with your questions. I'll come with my topic. So Estefania, should I risk going and doing the interview? So Estefania, it looks like I missed the other part of your question. Now, if you're talking about risk, so Estefania, I don't know what the situation is, but if you're talking about a risk, considering a risk, definitely a consultation. I don't even have to know what your question is. If you're saying, should I risk going? So should I risk going to the and doing the interview? Get legal advice in a consultation, because that means that there's something going on and you need to make sure that you are protected. So schedule a consultation. You can always call and schedule. You can even call now and the scheduling coordinator will call you tomorrow and book your appointment, because I don't like that. I don't like that word risk. If you are thinking about risking something, get that consultation. What if you're married to a dual citizen of Canada and USA? How long after the wedding you should put in your papers? So Rudy Tech said there's no rule that says that you can't submit your you have to wait for a while to submit your document. There's no rule that says that. Now, timing is going to depend on where you are, what is your status, what are your circumstances. But generally speaking, you could get married today and file it tomorrow. But the question is that a good idea? Because in some cases, under some circumstances, timing of your application could affect you personally, just depending on what's going on. For example, if you had a whirlwind romance on Friday, then you got married on Saturday, say you were in Vegas having a wild time, you met Friday, got married in a Vegas chapel on Saturday, and then filed on the Monday, that can look very suspicious. And so you want to be a little more strategic. Make sure you get guidance through it, and you still have to, because when you're submitting a marriage-based application, it still has to be a strong application to prove that, yes, you do plan to spend the rest of your life with this person. And so while there's no official rule that says you can't do this, you can't file your papers right after the marriage, the question is it a good idea? So for example, I have had clients who they got married and a week later we were filing their application. But what usually happens is that they were together for a long time. They had a long-standing relationship. And then, so they built on their relationship. They were already living together, or they were already doing a long-distance relationship. And then they got married and filed shortly afterwards. However, in a situation where it's a whirlwind romance, the officers can approach this with great skepticism. And so you want to make sure you prepare a good application. And in that case, timing could be everything. And so that is where you should get a consultation. So thanks again for all your questions. I appreciate it. I hope to speak with you in a consultation. Go to the link in my bio to schedule, or to see you tomorrow at 9:30. You bring your questions, I'll bring my topic, and we will jam it out again. Have a good night, everyone, and have a good week if I don't get to see you. So what if your spouse is living with you over a couple of months from his country and you guys married during the time? So, it's all going to depend. So that's definitely a plus. If your spouse lived with you for a couple of months in his country, that could be positive. But on a whole, it's going to depend on your full circumstances. Rudy Tech said, let's talk in a consultation, and let's talk about moving forward with your process after I determine fully that you qualify. Have a good night, everyone. Thanks for your questions. I appreciate it.